All right, everyone, welcome to City Hall. It is Tuesday, September 12th, and we are here for a special called session of the Athens-Clarke County Mayor and Commission to consider a single item, which is an appeal of an Historic Preservation Commission decision regarding a certificate of appropriateness for 120 West Cloverhurst Avenue. We do need to begin with a roll call, so I'll turn to Clerk Spratland for that.
Davenport.
Here.
Blank. Taylor.
Here.
Wright.
Present.
Fisher.
Here.
Poole.
Here.
Culpepper.
Here.
Myers.
Here.
Thornton. And Hamby.
Here.
We have a quorum.
All right, thank you, Madam Clerk. I appreciate it. All right, the order of these meetings, for those not familiar with them, and we don't do these that frequently, is that we'll first hear in a 10-minute block from all the proponents, and then in a second 10-minute block from all the opponents for this filing. And I do have Mr. McCormick, who signed up as a proponent. So, Mr. McCormick, if you'd like to step to the microphone, and you don't have to use all of your 10 minutes, but you may if you would like. Okay.
You signed up for 3 one time.
We'll give them as
Hi.
much as 10.
My name is Rich McCormick, and I live at 515 Highland Avenue. I prepared a very brief comment about what's ongoing at 120 Cloverhurst, or West Cloverhurst. So I live in the same general area and feel like I represent many constituents regarding the escalating number of short-term rentals in our neighborhood. In my case, there are 5 Airbnbs within 2 blocks of my house. And I feel like they don't do much to preserve the integrity of the neighborhood or the quality of life for full-time residents of the neighborhood. That being said, I understand Airbnbs are part of our modern life. I feel like, let me start again. I've walked from my home to 120 West Cloverhurst and just taken a peek at, what are the logistics of this? And it's pretty alarming in a way, and I'll get into that in a minute, but my understanding is that the Totten family is living in a single-family neighborhood in a historic district, in a home, a beautiful cottage that meets all current zoning and historic building parameters. On the other hand, the main house at 120 West Cloverhurst is kind of an anomaly. It's a non-conforming structure. I believe the fact that there's a breezeway now that's going to connect the accessory structure to the main structure now makes that part of the main house. And I guess what I'm getting at is the main house already has 2 rentals in it that were grandfathered. One is an Airbnb, and I think the other is on Zillow as a monthly rental. And the proposal to build a new structure is going to put another, more than likely, short-term rental on that same property. So what I find disturbing is that we're in a single-family neighborhood, but technically 3 families are being allowed to live at the 120 and a half property. And that just doesn't seem in keeping with the whole idea of a single-family neighborhood, in my opinion. And I don't think we want this to continue all over the neighborhood either. I might add that no one living at 120 or 120 and a half Cloverhurst is a full-time resident of the community and contributing to the neighborhood. I understand that they contribute to the tax rolls, and that's an important thing. I also understand that the owner of that property doesn't even live in our town. So if there's a problem, I guess you just have to call the police if people are being rowdy. And as I said, having walked to that area and also owning a house with a very similar accessory structure as the one that's being proposed, but one that is more than 30 feet away from the main house and not readily, well, it's visible, but it's not adjacent to another property. It looks like I realize, let me start again. I realize that the current carport is very close to the Totten's home. I mean, it's within 10 feet, it looks like. And I think looking at the proposed plan, that accessory building was not going to be in the same location as the carport. It was going to be moved closer to the main house on 120 and more centrally located. But be that as it may, from my own personal experience with a son who lives in our little apartment, plays the drums, has a job, and comes in at 3 o'clock in the morning from his DJ job downtown, there is a lot of noise clanking up those stairs to the apartment, something that the Tottens are going to be experiencing. There's noise from people being out on a deck that's in close proximity to your main abode. There's light pollution. It's really not a good quality of life that they're being offered should this go through. And I realize that from the context of meeting all of the building parameters through the Historic Preservation Committee, all the check marks can be made. It's not in violation. But having said that, it just doesn't seem like an appropriate use of that property if we're concerned about people that live in this town full-time, that retire in this town, and want to have a peaceful life. I guess that's all I have to say.
Thank you, Mr. McCormick. All right, and do have 3 opponents signed up, Mr. Reeves, Mr. Williams, and Mr. Matheny.
Mayor Gertz, I am here speaking for the appellants who have the right under the process to have some time here as well, as under subsection A. My name is Matthew Totten. I'm here for John and Susan Totten.
So you can have the balance of the 10 minutes?
Yes, I definitely understand. Mr. Totten's here today wearing the blue Navy hat. I want to make sure the neighbors had opportunity to speak because I know there's a fair number here in attendance today who have expressed a lot of distaste for what's being proposed. Just to keep it short and sweet with y'all, this application has 2 notably significant issues here. One, really focusing on the design guidelines. Design guidelines, whether we're talking about new construction, alterations, or accessory structures, goes to the same calculation. Really, and here on this application, we're talking about scale, which the design guidelines make clear as visual sizing and height and dimensions. Massing, which is just basic geometry. Simpler the better is preferred under the design guidelines. And then details in the structure, which is pretty self-explanatory. And whether you're looking at it under as an addition, accessory, or new construction, the design guidelines ultimately emphasize a lesser scale, so smaller structure versus the main one, simpler form, and lesser details, especially on a contributing historic structure such as 120 West Cloverhurst. The application notably does not show the proposed height of this, especially accounting for topography versus the existing conforming historic structure, which, looking very closely at the details, unquestionably will dwarf it and light that 6-foot height topographic difference with the proposed construction being higher. Further, as to the massing and the details, the exterior wraparound staircase and the second floor party deck add geometric complexity and details you won't find anywhere else in the Bloomfield Historic District, which will stick out like a sore thumb and certainly not contribute to the historic district. Additionally, as the planning staff highlighted, the extensive dormers contrasted with the existing structure, which is relatively simple in nature, is going to be way more complex in detail and massing than what is there today. Secondly, this body, in considering the HPC appeal, can also consider use in some instances. Under Ordinance 855F, which is within the Historic Preservation Ordinance, permits the HPC and y'all to consider use which has an effect on exterior architectural uses. As a practical matter, there are numerous exterior details which go to the proposed uses as a second-story living structure, notably the wraparound stairs and the party deck on the second floor. As Mr. McCormick highlighted, that it's a non-conforming use. There's 2 existing rental structures there, and Georgia law is quite clear, as is this county's ordinance, notably under 915-8A, that a non-conforming structure may not have the element of its non-conformity enlarged or extended unless a variance is issued. So for historic preservation purposes, looking at it very straightforward, this body can consider the use as additional living space and contrast it with what is going on in the ordinance. Georgia law is very clear that in light of the county's ordinance, that you don't have to accede to this out-of-towner's non-resident's wishes to create additional party space, create additional rental space. Even though the applicant attempts to assign that additional living space to the main house versus being an accessory structure, there's the same concern, because ultimately all you're doing is adding another bedroom of living space to that non-conforming use. And as an analogy of what the applicant is trying to do, it would be the equivalent of someone trying to take one-bedroom duplexes and convert those into 3-bedroom duplexes by adding spaces. Y'all know as well as the law does, just in common sense, that is not permitted, whether under historic preservation analysis or zoning, a zoning framework. Further, as I sent this body in a supplemental brief last night, in light of the applicant's filings, there's actually 3 ways that he concedes that the application should not be given a seal of approval by this body tonight. Importantly, the applicant actually conceded that its application violates county ordinances in light of the non-conforming use and the grandfathered 2 units at the structure. And further, the applicant makes an interesting argument that the HPC considered this or should have considered this as an addition as opposed to an accessory structure. However, if you go back and look through the planning staff material, you look through the transcript material, all that's before you tonight, the staff and the HPC limited its discussion to this under Design Guidelines 4G, which addresses accessory structures. So even if you take everything that the applicant's going to try to convince you tonight, he directly conceded that the HPC and the staff used the wrong portion of the design guidelines to give its approval. Ultimately, I think this is a very clear open and shut case for y'all, and that this commission must ultimately reject the Historic Preservation Commission's decision as the application and approve in the entirety the points of law and factual error raised by the appellants. Thank you all for your time.
Thank you, Mr. Totten. Right, and again, I have 3 members of the public who are going to share the opponent time. Again, total of 10 minutes, and you may divide this time however you'd like. I have Mr. Reeves, Mr. Williams, and Mr. Matheny.
Mr. Mayor, members of the commission, I'd like to introduce Jason Williams, the property owner, to speak in opposition to the appeal.
I'm Jason Williams, owner of 120 West Cloverhurst. I'm here to defend myself, my family, and our project from the appeal launched by the Tottens. This appeal mischaracterizes our project. While I'll let David and Matt get into the legalities and technical aspect of that, I thought it was important that I tell you about myself and why we're doing this project. I was born right down the street, St. Mary's Hospital, went to Timothy Road Elementary, the old Bernie Harris Lyons High School, graduated from Clark Central in 1998, and then University of Georgia in 2002. I have lived in Athens longer than I have lived outside of it. My parents, Randy and Carol Williams, still live in Athens in my childhood home off Timothy Road. My sister and her husband, Lauren and Joe Perloff, also live in Athens in the Beechwood area. The entire reason I have my beautiful wife, Jennifer, is because she fell in love with Athens and came here from Pennsylvania to attend the university. While my job requires I live in Atlanta today, I still consider myself very much an Athenian. It is my hope and plan that I will also return here one day, and this addition to the house as part of that plan. Three wonderful and quickly growing boys, 10, 8, 6, and hopefully they will be Athenians at some point in their future as well. Contrary to the Tottens' assertions, I'm not an out-of-towner with no ties to the community and a desire to operate Airbnb business here. When I purchased the house 9 years ago, I had a wife and one small child, and the home fit our family perfectly. We have already had so many memories with the house, with family and friends over, and in fact, it was at my grandparents' dinner table, which is in that house, where we announced that we were expecting our second child, Sawyer. We look forward to many, many more memories we make, but as our family has changed, the house needs to change to allow us to continue to enjoy the space, use, and enjoyment that the house can provide. And when we decided we wanted to make this addition, we knew that we wanted to do it the right way, which is why we called David Matheny to be involved with the project from the outset. We wanted to make sure that the home recognized the existing structure as well as the overall feel of the Five Points area. And so what we're doing now is taking a non-compliant accessory structure, carport, which is also not very attractive, and making that a conforming, beautiful, and matching garage and living area. The property does have a rental unit, and it's had that rental unit for 50 years. That's one of the reasons that attracted me to the property, because it, as a second home, I wanted somebody to be able to live there full-time. It's a single-bedroom rental unit. In the 9 years that I've owned the property, it's always been inhabited by either young professionals or graduate students. We haven't ever been a nuisance to the community, and we don't ever plan to be. So with that, I'll kick it over to Matt David to let you share more about the project.
Thank you, Mr. Williams.
As David Matheny comes up, I have a copy of the brief we filed on Friday. Does anybody want a copy, an extra copy? All right, David Matheny, architect.
Good afternoon. I wanted to say, as the architect for this project, that it's my perspective that the Tottens are appealing the HPC ruling, which in my mind means that they are appealing the HPC-approved design of the new garage addition, which should be, in my mind, that they are limited to discussions about the size, the exterior design elements, and materials, windows, placement of windows, sizes, style. HPC does not generally take into consideration placement on the lot or the amount of coverage of the lot, or how the structure may or may not be used. HPC is charged with determining how the addition relates to the existing house with regards to the scale, style, and architectural elements such as windows and window style, sizes, and placement. And therefore, the focus of the Mayor and Commission needs to be limited to what HPC has approved as an addition to 120 West Cloverhurst. I think it also needs to be noted that this is the second time that this particular design has come before the HPC Commission. Previously, it came about 2020, when right around the time of COVID, which means that the project was not able to get started, and so therefore it expired, and so we had to go before HPC a second time, and it has been approved twice. And so I think we need to focus on HPC's approval. Thank you.
Thank you, Mr. Matheny.
Mr. Mayor and Commission members, my name is Matt Reeves, Anderson Tate and Carr Law Firm, here on behalf of Jason Williams. The HPC got it right, and we are respectfully requesting you to affirm and enter the HPC's decision, which was supported by the Athens-Clarke County professional staff who analyzed the HPC application before the HPC did. Mr. Matheny was one of the original members of the HPC decades ago and has attended the HPC on a monthly basis for many, many decades and is very diligent and conscientious about compliance with Athens-Clarke County standards, and this application in all respects complies if you analyze it correctly. The appellant's appeal has a number of flaws in analysis, but the big picture is you have a cinder block carport near the property line. That is an accessory structure that is non-conforming. That is being removed completely as a result of this HPC decision. There will be an attached garage, which is much more architecturally attractive, matches the neighborhood much better. It will have a bedroom upstairs without a stove. The staff and the HPC have analyzed it carefully. There are second floor decks all throughout the neighborhood, including immediately across the street. Everything in this application matches Athens-Clarke County standards. It is an attached structure. The original structure was accessory, and it was non-conforming, and that will be eliminated. And one of the goals of Athens-Clarke County standards regarding historical analysis is to mitigate and eliminate accessory and non-conforming structures, and affirming this application will do just that. The garage and the bedroom above it serves the main dwelling, not the duplex. The duplex is not being affected whatsoever. That is a red herring in this appeal. The duplex will not be touched. There won't be a single square foot added to the duplex. As Mr. Williams said, the duplex has been there for decades. This garage and the bedroom above it will serve the main living space, which is used by Mr. Williams and his family. There was also a red herring argument about short-term vacation rentals, and that is a zoning-related matter, not an HPC matter. But for the 9 years that Mr. Williams has owned the home, he's complied with Athens-Clarke County standards. There have only been about 10 days the home has been rented for short-term rentals over those 9 years, and that's similar to the way they do it at Augusta National. It is not something that is the primary use of that main dwelling. The primary use is for Mr. Williams and his family, and that garage and that living space above it will serve the family residence, which, as he mentioned, currently is his second home. Long-term, it's where he wants to move his family. This is an attached addition to the home. It's within 15 feet of the home, which is Athens-Clarke County standard. It is aesthetically and architecturally attractive. The new addition's design and appearance complements and matches the main home's appearance and architecture. Mr. Matheny would have nothing less. Athens-Clarke County's professional staff would have nothing less, and the HPC would have nothing less. Everything in this application, which was approved by the HPC, complies with Athens-Clarke County's high standards. And the decades that the Williams family has had invested in this community, they want high-quality standards. This is something that will attach the garage to the structure and make it more aesthetically pleasing and more historic looking in the neighborhood. This argument, inflammatory words by the appellant, party deck and things like that, nothing of the sort. This is a bedroom and garage for the Williams family, and that it's been reviewed by architect David Matheny, the professional staff, and the Blue Ribbon Athens-Clarke County Historic Preservation Community. The Tottens don't have standing to appeal. They don't have any legal rights that are affected. You've been patient hearing this appeal. We would ask you to affirm the Historic Preservation Commission's sound decision in which they and the professional staff of Athens-Clarke County got it right. Thank you, Mr. Mayor and members of the Commission.
Thank you, Mr. Reeves. All right, Commissioners, as you know, your charge is to consider the transcript of the earlier HPC hearing.
Here's opportunity to do a 3-minute proposal.
3 minutes is yours.
Thank you, Mayor. I'd just like to hit on a few points raised. Certainly, the basis for an appeal here is for a party that's adversely affected. And if you took the opportunity to take a look at this proposed site and the adjacency to my client's property, I think being adversely affected would be an understatement. There are a few things that Mr. Reeves misstated, whether accidentally. Well, for one thing, the garage that's existing there has been there as identified by the staff for at least 50 years. That actually is not a non-conforming structure. It is exactly like the use of 120 West Cloverhurst. It is a grandfathered structure which happens to be in setbacks. It is certainly conforming, and there was some discussion, I believe, in the planning report about whether that garage might also be a contributing structure, but they could not identify what the precise date was. Certainly, I understand Mr. Matheny's desire to defend what he was paid for to present here, but y'all's ordinances are clear that y'all can directly consider use under 855F, which again says you can consider use which has an effect on exterior architectural features. Mr. Reeves mentioned that there, without it citing any property specifically, that there were decks all over the place, second-story decks all over the place, wraparound stairs all over the place. However, if you guys look at 3 recently constructed structures that are similar to this one, located at 166 West Cloverhurst, 124 West Cloverhurst, and 440 Bloomfield, and note that these are all within 500 yards of the proposed structure, none of them have exterior stairs to access the property, and none of them have an exterior party deck. And ultimately, I think, while I appreciate Mr. Williams' long-standing ties to the community, that's really not germane to what you're all looking at. And no matter what his expressed intent or desire to the property is, the proof is in the pudding. They are very clear that this is a second home, that the rental unit is not going away, and that they continue to this day market the property as an Airbnb rental unit. So certainly, y'all can consider the use, which Mr. Reeves falsely says has nothing to do with the main structure, when in what he sent over on September 8th to y'all identified the additional living space to be directly ascribed to the main living structure. It's easy to take what I sent over to y'all late last night and use the applicant's words against them. They admit that this doesn't pass muster. I understand that they felt like they had hay in the barn back from 2020 during COVID, but as you can see with my elderly client, who was going out there to view and oppose and appear at public meetings at that point. So I think it's a gross mischaracterization to think that the 2020 application and review has anything to do with this today at all.
Thank you, Mr. Todd. All right, Commissioners, as you know, you have the transcript of the HPC meeting and the submission in front of you, which is your material to consider. And so given that, I'd entertain a motion regarding this item.
Mayor, I'd just like to ask a few questions before I make a motion, if that's all right. Just
Please,
some clarification,
absolutely.
help us all understand this.
Austin here from the County Attorney's Office.
Of Austin. So, Austin, is there are there different guidelines for additions and accessory structures?
That's an excellent question. And so, as you all have heard, the breezeway connection that connects the proposed structure to the main residence allows staff to treat that as an addition. However, there are no, the design guidelines does not contemplate the existence or absence of a breezeway, and so that is why staff and the HPC did apply the accessory structure guidelines.
Okay.
Because the addition does not.
So if it were an addition, would it be in a different guidelines from the 4G guidelines that they looked at?
I'm sorry, could you just repeat that?
Would there be, if we're considering it as an addition, are there different guidelines? They're considering an addition, but within the document here and within the presentation to HPC of the staff report, it looks like they were using 4G guidelines for the, but are there, I guess what I'm asking, are there guidelines for additions that are in a separate section?
There are not, and what helped me kind of wrap my head around it was you have the code of Athens-Clarke County as one source of authority, then you have the design guidelines.
Right.
Under the code, and we can treat this as an addition. However, because the design guidelines do not contemplate a breezeway connecting structures or anything like that, then that's why they applied the accessory structure guidelines.
Okay.
And it was an existing accessory structure.
Yeah, and I've driven by there many times since we received this appeal and checked out the area, and I've been very familiar with it. I have another question too, and this is probably just related to the zoning and the non-conforming, and I'm not going to get into use or anything, but it's my understanding, and I could be completely wrong. It's what I'm hearing from some folks. over the years within the Bloomfield District, that the previous land use plan allowed for the existing sort of duplexes and stuff, but once it's sold, then it reverted back to single family. Is that not the case?
My understanding is that the non-conforming element of this property is grandfathered in, and until such time that, as the property owner abandons that non-conforming use,
No,
then it's
the
not.
property owner can buy it like that, but they would have to abandon it in order for it to revert back. Is that right? They can't change it to one
Right, so
use.
it runs with the property, unless whoever owns the property at the time no longer
Okay.
uses the property that way for a period of time that's in the ordinance, then it's abandoned.
And I'm just going to play it safe and not get into use, but I am going to make some comments about the design. I do think Mr. Matheny does excellent work, has always presented some really good stuff to us over the years. However, with this project, I do think, and if you look at it, with the addition or accessory structure, however you want to look at it, it does not, if we consider it an accessory dwelling, which is what their guidelines are doing, it doesn't look subordinate to the main structure at all. It looks just as big, really, as the main structure, as the main house. And, you know, the point was made within the area. If you look at the context of historic districts, you look at other homes and other additions within the area of that historic district, you are hard pressed to find anywhere where there's a deck as large as this deck within the existing historic district. So with the scaling, with the subordinate and the massing, you know, and I'm just real confused about the breezeway aspect of it too, the addition of the breezeway, and trying to fit that into the main structure of the house, but then going by accessory dwelling. So, Mayor, with that said, and with just some of the concerns and that I've heard or read from the report and questioning in my mind, I don't think that the HPC abused their discretion, but I would like to make a motion to modify their decision and deny the request.
There's a motion to indicate that the HPC did not abuse their discretion, but that the request determination is modified. Is there a second?
Does everybody understand what the motion is? We have an option where we can say that the HPC abused their discretion. We have an option to say that HPC did not abuse their discretion or modify their decision, or we have an option to accept the HPC decision. So what I'm saying is HPC did not abuse their discretion, but I'm modifying it to deny the addition and support the appeal.
I'll second.
Got a second from Commissioner Link. Commissioner Link, any follow-up?
Yeah, I mean, I
remarks?
think the crux here is this breezeway. There's no mention of such a connecting structure in the design guidelines, and there's no precedent for it in this historic district. This is being treated as an accessory structure, yet it's in violation of many of the details of that 4G section of the design guidelines. The massing is more complex. That wall of dormer windows is not analogous to, you know, the really understated dormers in the original structure. And the scale is very similar, especially from the corner. You know, being that this is a corner lot, it has a double impact on the historic district. This might not be an issue if it were between two existing structures, but you know, we look at this as a district as a whole and the impact of new construction on a district. And this certainly will have an impact on the district as a whole. And I feel like, you know, if the applicant, you know, wanted to convert this to a single-family home to house his family, as was stated, I don't understand why it's not just, didn't come across as an addition. Why is that breezeway necessary? That's a really odd structure, and the only thing it says to me is that breezeway is constructed to avoid accessory structure guidelines in our zoning code, because as an accessory structure sitting alone, it would violate our zoning code. It's larger than what our zoning code allows. And also the living space is not allowed by the zoning. So I agree, this is a really odd bird, and that breezeway is the crux. It's not conforming to the architecture of the district. It's not mentioned in the guidelines. I'd rather see this project come back as a proper addition, and maybe with an additional accessory structure to function as a garage.
Is there any other questions for Austin or observations from the members of the body? Commissioner Houle?
Yeah, thank you, Mayor. Due respect to my colleagues, I'm sitting here feeling like I have the opposite opinion. So I guess I'm going to make a substitute motion to uphold the HPC's decision, and if I get a second, I'll explain my rationale.
All right, I've got a motion, a substitute motion from Commissioner Houle to uphold the HPC's opinion, second from Commissioner Davenport.
Thanks. Yeah, I made some notes here. I actually didn't think I'd have to read them. I'm just going to read what I wrote. Residents have raised valid concerns regarding short-term rentals generally, and I think we would do well to, and I believe we should regulate short-term rentals, Airbnb or otherwise, but that is not the question before us today. The applicant and the appellants who spoke today seem to me like very nice people who genuinely care about Athens, but their character is also not what's before us today. We hear consistently from residents that housing affordability, fiscal responsibility, and environmental sustainability are paramount concerns. Separately, I also happen to believe that we need more density, which includes more accessory dwelling units, different from what our code would call for. Counter to maybe part of the argument that we heard from the attorneys representing the applicant. But that too is not the issue before us today. The question before us today is, did the HPC act appropriately in approving their certificate of occupancy by determining that the application did meet all design guidelines and therefore did not have an adverse effect on the property or the district, and specifically with regard to the legal definition of what our code defines an effect on the historic district, not what people feel about our community. And I think these concerns that we're hearing from residents are valid, and we should act on those, but that's a separate action that needs to be taken. So if we're looking at the existing structures, if we're looking at their design, if we're looking at the law, I believe our staff and our attorney's office have provided a solid analysis that supports the HPC's action.
Thank you. Commissioner Davenport, a follow-up?
Commissioner Hall summed it up. So we're literally here just to look at the COA and look at how, and I saw the videos of 2020 and the recent historic meeting, and I think, yeah, I disagree. Just agree with what Commissioner Hall said. He can articulate it better than I.
Any other questions for Attorney Jackson or remarks, Commissioner?
I have a question. I drove by or cycled by the site today and looked at it, and I looked at the video of the meeting, which was actually quite short. But I do want to understand the approval for the building itself. So we have the Historic Preservation Commission and what they're looking at, but there's also planning and zoning codes and building codes. So could you just clarify for me how these have been reviewed through the planning department, or is that,
It's a great question. And so, as has been mentioned, the historic preservation is simply focused on the project's compatibility with the design guidelines. Any other issues such as a non-conforming use or anything like that, that would be covered under a zoning permit that goes through a separate process through the planning department.
which is still to come?
I do not know if it has been issued at this point. I think we do have a representative from planning staff here.
We do.
If you want to invite him
Assistant
up.
Planning Director Bruce Lonnie. Mr. Lonnie, I apologize. Do you mind just a second? Just wanted to know where this is in the process of getting an approval for construction.
Sure. So standard procedure for any kind of COA that's coming through, the COA approval comes first, then we receive a zoning permit submittal for the construction. Because of this, pending this outcome, there's been no action taken on any construction permitting.
we've held until that happens. The COA is issued concurrently with the zoning permit that then is connected to the construction permit. So no construction permitting has taken place at this point.
Thank you.
To
That answers
further
the question.
clarify that, so is what's being proposed, can that be then built by right? Does that have to go through any planning process, approval, planning commission approval?
Absolutely, we would go through that process. So as attorney, as Austin has pointed out, the design guidelines have been addressed by the HPC. So then the planning department's role is to look at use and the other development standards that come into play. That evaluation is yet to come. So anything related to the single family versus legal nonconforming versus all of those types of things, that is yet to come.
So the extension versus the auxiliary dwelling and
Right, I can clarify that. Breezeways are very common in historic districts. They're actually promoted by the design guidelines. And so the use of a breezeway for accessory structures is actually a design tool to ensure compatibility and to not confuse the historical interpretation of the original resource from the new construction. Our development standards, however, have had to draw a distinction of when something is an addition to a house versus an accessory structure. And the 15-foot-long breezeway is a standard that's in the zoning code, separate from the design guidelines. So that, and that's, I think, been talked about earlier, but that is something that we'll sort through as part of the zoning process. But what's been submitted and approved is under the 15 feet, and so it would not be considered an accessory structure. It would be an addition by zoning standard, if that helps.
Commissioner Hamby, did you have a question for?
No, I don't have a question, just a comment. You know, I think the confusion over addition versus accessory structure ought to lead us to thinking that perhaps this, the modification motion that I made should go forward. You know, certainly I think it does set precedents, but it also looks at the, you got to, as Commissioner Link said, you look at the houses within the historic district to help you make your determination. And you go from there. So, you know, if they're going by an addition instead of accessory, if they're going by accessory structure, Commissioner Link is exactly right. You know, if you look at the floor plans, there's a bedroom, a living room, and a kitchen in there. That's not necessarily an addition to a home. That's you know, so you see where I'm going with that. So I think I've made my point. So.
Any input from a member of the body that's not provided any input yet? Commissioner Houle?
Thank you, Mayor. Yeah, I think my colleague's point is well taken in my.
Public input has ended. I apologize.
I also realized, I think in my remarks, my kind of unprepared remarks, I think I said certificate of occupancy. I'm sorry if that sounded unclear. Certificate of appropriateness, COA, not CO. Just like, I don't talk about certificates of appropriateness nearly as much as certificates of occupancy. Anyway, why I do think this is appropriate still is, ultimately we can get into our subjective interpretations of what the structure might be used for and what's going on inside and who's going to be there, but that's not really the matter that's before us today. We're charged with looking at what the structure is, what it's being proposed to be built, does that meet the guidelines? Other legislation that we may want to pursue around how those properties can be used, which is legislation I am interested in pursuing, would be great, but that's not what we're being asked to do today. And so I do think we should uphold the decision. Thanks.
All right, so we've got a substitute motion on the floor from Commissioner Houle, and we will dispense with that first. So, Madam Clerk, if you could call roll, beginning with Commissioner Houle.
Houle,
Yes.
Culpepper,
Yes.
Myers,
yes.
Hamby,
No.
Davenport,
Yes.
Link,
No.
Taylor,
No.
Wright,
No.
Fisher.
Yes.
5 yes, 4 no.
All right, so matter settled. I appreciate it, everybody. All right, entertain a motion to adjourn.
So moved. Second.
All right, got a motion from Commissioner Fisher, a second from Commissioner Taylor. All in favor, please say aye. Aye. Any opposed? All right, we're adjourned until 5:30.